We have the public defender that's available to you. If an offer is able to be made to resolve your case today, I will let you know and possibly be able to resolve your case. Okay, the first case that I have is Brian LaPiedra.
Mr. LaPiedra is here present at main judge. He declined to serve as a public defender for count 1.
Okay, and I see Mr. McLawrence is there. Hello, Mr. McLawrence.
Hello, good afternoon, Judge. He has in counts 2 and 3 are municipal ordinance cases. He
Yes.
says that he never received notice, so that's why he didn't appear for court. And count 1 is the new misdemeanor battery. Judge, he wanted you to know that he's gainfully employed. He does subcontracting work. He's been living here for 3 years. His wife and his 2 children live here with him. He does acknowledge that he had a 2000, he believes it's year 2000 felony DUI. He's asking, Judge, for as low a bond as possible on count 1 so that he'd be able to bond out.
Okay, so Mr. LaPiedra, good afternoon. You're here on a domestic violence battery charge, and as your counsel indicated, on counts 2 and 3, you have capiases issued for missed court date. I've reviewed the probable cause affidavit, and I do find probable cause for count 1, the domestic violence battery. The court is going to set bonds. Hold on here. Okay, the court's going to set bonds at $3,000 on count 1. You currently have $200 on each capias. The court's going to order no contact with the alleged victim in this case, Maritza Salway.
Judge, Mr. LaPiedra is asking if the court would be inclined to possibly reduce count 1 to a $1,000 bond. Together with the other 2 bonds, he might be able to post that, but as $3,000, he wouldn't be able to post it, Judge.
What's the state's position?
Looks like this was done in the presence of a 3-year-old. I think based on the allegations, the $3,000 bond is appropriate.
Okay, Mr. McLawrence, based upon what I read here in the probable cause affidavit, I am going to leave bond at $3,000. Good luck, Mr. LaPiedra.
I can't see. I'll talk to him.
All right, he does have a court date June 5th. Okay, then I have Attila Angel Kennedy.
She's a North Broward judge. And Your Honor, just so you're aware and so the in-court clerk is aware, I'll bring the orders up to your court.
Thank you.
Medical reset, Your Honor.
Oh, okay, thank you. All right, Mr. McLawrence, this, Ms. Kennedy was a medical reset.
Thank you, Judge. Take
You're
care.
welcome. Have a good afternoon. Courtney Michelle Grady.
She's in North Broward also, Judge.
Courtney Michelle Grady.
Not bad.
Hello, Ms. Grady. Ms. Grady, you're here on 2 violation of probation warrants. There's no bond hold, but you do have a court date on May 30th to address those cases. Good luck.
Thanks.
You're welcome. Nicole Elizabeth Kokatsa.
North Broward also.
Thank you.
Hey, ma'am, how are you?
Hi, Ms. Kokatsa. Now, you're here on a possession of possession of cocaine, drug paraphernalia, resisting without violence, failure to obey police, and you have 2 traffic tickets. I've reviewed the probable cause affidavit, and the court does find probable cause. You have bond set at $1,000.
Okay, ma'am, thank you.
Your Honor, Ms. Kokoza indicated to me that she's represented by Kevin Kulik. I was not able to reach Mr. Kulik this afternoon, so I'll call him after court and let him know what you're being held on, okay?
Okay, thank you,
Okay,
Ms.
you're welcome.
Reed. Anthony Frederick Woods. Hi, Mr. Woods. Mr. Woods, you're here on a suspended license charge. I do find probable cause. Bond is set at $100. This is not a case that we're going to be able to resolve today, but you have a $100 bond.
Thank you.
Ryan James Nolan.
Mr. Nolan's here, President Maine. He's approaching. Come on up, Mr.
Thank
Nolan.
you. Mr. Nolan, you're here on a DUI charge and 2 traffic infractions. The court does find probable cause. You have bond set at $500.
Judge, if the defense could be heard, and speaking with Mr. Nolan, he's basically relocated. He was living in Washington, D.C. He's now made South Florida his home. He's currently employed. He works for a company called Better Process. He's like basically their accountant. He's been working there for 1 month. He's making about $23 an hour. Because he just relocated, he just started employment, he's not really, his financial resources aren't really overflowing at this time. He is living in Coconut Creek. He's been living at the apartment now. He just signed a contract. He's paying about $500 a month. He shares those expenses with a roommate at the apartment. Judge, in speaking to Mr. Nolan, this is his first arrest. He did tell me he was a registered voter in Washington. He plans to go ahead and become a registered voter down here in Broward County. Judge, considering this is a nonviolent offense, his first exposure to the criminal justice system, he seems to be establishing strong ties in our community. We'd be asking you to consider an R1 on Mr. Nolan's behalf.
Okay, what's the state's position?
That he can't afford a $500 bond. $23 an hour.
Judge, we can't hear anything what's going on. The microphone is cutting in and out.
Okay, Mr. Linder, you got to speak into the microphone a little better. Just repeat what you mentioned.
Just asking the court to keep the $500 bond in place. It appears, based on his breath results, Mr. Nolan has limited ties to the community, and I really haven't heard anything to indicate that, based on his financial ability, that $500 would be unreasonable.
All right.
Well, there is a presumption, Your Honor, this nonviolent offense be released on non-monetary conditions. And I was just bringing that point up because, Mr. Nolan, this is his first arrest. I don't know if the state can verify, but if they can, I would think Mr. Nolan would be an appropriate candidate.
Okay. Under the circumstances, based upon the allegations that are complained in the arrest affidavit, the court is going to leave bond set at $500. Good luck, Mr. Nolan. Leviticus Brown.
Mr. Brown, come on up, please.
I'm
Judge,
sorry?
speaking Mr. Brown, he advised that his older sister is going to be posting his bond.
Okay, is that what you just said? Okay, that's what I just heard.
It's
Good
posted.
luck, Mr. Brown. It's posted.
Good luck, sir. It's posted. Yep.
David Rothenberg. This is the case that we reset from this morning. Yes.
Waive formal reading of the allegations, Judge.
Okay, understood. All right, so Mr. Rothenberg, and I need some assistance in this because I have 2 sets of paperwork. One set that I received this morning shows these charges as capiases, and then the second set I have show them as actual charges, but it appears to me that they were issued as a capias pursuant to an arrest warrant.
I believe I can explain everything to the
Please.
court, Your Honor. Counts 1 through 7 is a refiled, not in custody information.
Okay.
This case originated, counts 8 through 12 are from the original arrest warrant that
Now, 8 through 12, I only have 8.
there should be a new paperwork,
Oh,
book
yes,
issued.
yes. I do see it. You're correct.
Okay.
8 through 12.
This case originated with an arrest warrant. It was never served upon him. Mr. Rothenberg was arrested and charged with federal offenses, and he went through federal court. He pleaded out. He was actually extradited here from Federal Bureau of Prisons. He's currently serving a 17-year federal prison sentence, Your Honor.
Okay.
So during that time, the state filed the non-custody information, actually null-processed it and refiled once he got through his federal process. And that is what 1 through 7 is. What I'm going to ask the court to do is whatever findings you make on 1 through 7, that's in the court's discretion. On 8 through 12, there's PC based on the arrest warrant, but I'm going to be asking the court to ROR him on those counts because the allegations that are covered by those counts
Yes.
are the basis for the information filed in counts 1 through 7.
Okay, so you're asking the court to set a bond on 1 through 7 and ROR him on 8 through 12?
Well, not exactly. On counts 1, 2, 3, 4, 6, and 7, those are punishable by life offenses and or capital offenses, Your Honor. He is bond eligible on count 5. Does Your Honor have a copy of the arrest warrant affidavit, though?
I do have the arrest warrant,
Those
yes.
are the allegations that form the basis for the charges, so I would be, at this point in time, just relying upon.
I don't have it.
Here, I have it right here.
I have, okay, thank
Here,
you, Judge.
just take my copy.
Could I have just a
Yes, okay, so Mr. Rothenberg, on counts 8 through 12, the court is going to ROR you on those counts pursuant to the state's request. And the matters that we're dealing with here are counts 1 through 7. Now, the state has made an argument that you should not receive bond on 1, 2, 3, 4, 6, and 7, and that the court should set a bond on count 5 because it's not a life, it's not a felony punishable by life. So I'm going to let the public defender read your arrest affidavit and respond.
We're ready to proceed, Your Honor.
Okay, I'm ready to hear the...
For the record, I have read
argument.
the affidavit.
Okay.
It's going to rely upon the contents of the arrest warrant affidavit. I believe that the contents of the affidavit, for first appearance purposes only, do rise to a level of proof evident or presumption grade. Would be seeking, and if the court agrees and sets the bonds at no bond on the punishable by life offense counts, I would leave the bond on count 5 to the court's discretion. And obviously, we'd also, in an abundance of caution, ask for an order of no victim contact.
Okay, thank you, Mr. Linder. Let me hear from the public defender.
In light of the fact that Mr. Rothenberg is currently being held on the federal prison sentence, we would defer any argument regarding proof evident presumption grade at this time.
Okay, so Mr. Rothenberg, I have reviewed the arrest affidavit, and based upon a reading of the arrest affidavit, the court does find that that is sufficient to establish that proof of guilt is evident and the presumption is great in order to issue no bond hold on counts 1, 2, 3, 4, 6, and 7. Now, count 5, you are eligible for a bond, which I'm going to set at this point in time in the amount of $25,000. The court's going to order no contact with either of the alleged victims.
Yes, Judge.
Now, was it my understanding that there was going to be an ROR on counts 8, 9, 10, and 11 as they are duplicitous?
12.
Was that the understanding?
Yes.
Okay.
8 through 12.
Yes, and I imagine once a case number is assigned to that arrest warrant, the state will be no infoing it since we've already filed.
Okay, very good. Thank you. All right. Jermaine Walker.
Mr. Walker, is your present, Judge, your name?
Hello, Mr. Walker. Mr. Walker, you're here on a petty theft charge, battery on law enforcement, resisting with violence, and you have 3 violation of probation or community control warrants. The court does find probable cause. On the petty theft, you have a $25 bond. On the battery, the court is setting bond in the amount of $3,000. On the resisting with violence, the court setting bonds at $1,500. You have a no bond hold on the probation violations, and you are going to court on June 5th. The court's going to order no contact with the alleged victim.
Judge, we'd only be requesting a photo order on Mr. Walker's behalf.
Your request is granted.
Thank you.
You're welcome. Robert Moses Cannon.
Mr. Cannon is here present, Judge Amin.
Okay, Mr. Cannon, you're here on a burglary of an unoccupied conveyance charge and loitering or prowling. The court does find probable cause. I am entering bonds in the amount of $7,500 and ordering no contact with the alleged victim.
Judge, if the defense could be heard, my understanding Mr. Cannon has been residing in our community for 20 plus years. He is 23 years old. He just obtained employment. He works in the city of Doral for a company called CTI Security. He just started last week. He's getting paid approximately $10 an hour. He's waiting on his first paycheck. He lives in Miami. He lives with his sister. They've been residing in the same residence for 2 years now. His portion of the rent, which he shares expenses with his sister, is $300 per month. Judge, he is hoping that his girlfriend or his sister would be able to help him post a monetary bond. However, $7,500 would be out of reach for his family. But we consider this as a third-degree felony. It's an unoccupied conveyance. Judge, we'd be asking you to consider a $2,500 bond on Mr. Cannon's behalf.
Okay, thank you. Let me hear the state's response.
I don't know if he has a record now, but I would just note, Your Honor, even though it's listed as a third-degree felony, Your Honor, it is possible that he could be facing an enhancement. There is an enhancement if any individual crosses county lines to commit a burglary, as listed on his booking sheet, and as Mr. Romero just stated, Mr. Cannon is a resident of Dade County, and it appears he crossed the county lines to commit a burglary in Broward County. That would raise it to a second-degree felony.
Okay. At this point in time, Mr. Cannon, the court is going to grant your attorney's request. I am going to reduce the bond to $3,500 on count 1. All right, good luck. Juan Carlos Argueta. Mr. Argueta, you are here on carrying a concealed weapon by a felon.
It's a change of charge, Your Honor. It was changed to, one moment. It was originally possession of weapon and ammunition by a convicted Florida felon.
Right.
And it was changed to carrying concealed firearm by a convicted felon. Bond was originally set at $100.
At $100? Okay. And is the state comfortable with that bond amount?
Your Honor, I really don't. Since it's essentially a lateral change,
Okay.
I don't really believe I have a basis to ask for modification.
Okay, I appreciate that. Mr. Argueta, this is a change of charge. The court's going to leave bond set at $100. All right, good luck.
He's being held no bond also. So.
Oh, okay. Emmanuel Colin?
Advised that Mr. Colon is actually in court, Judge. He was taken to his regular division this afternoon.
Oh, okay. You know what? There was a court order for him to be brought tomorrow morning, but if he's been brought to court today, we'll remove him from the magistrate docket.
That's what the North Broward Detention Center advised me.
Thank you very much. Okay, and then I have Jonathan Edward Mayo.
Mr. Mayo's approaching, Judge. My understanding also he's being held on other matters. He has a no bond order.
That is correct.
Okay, so Mr. Mayo, you're here on 2 change of charges to false ownership information on a pawn item. Bond is set at $3,500 on each count. Good luck.
Good luck.
Okay, and did we did we do Leviticus Brown? Did we take care of Leviticus Brown? Leviticus Brown? He bonded. Okay.
Oh, he bonded?
He did bond. Okay. So then
Judge, we have one last gentleman here at Maine.
What's his name?
His name is Sean Samuels.
Yes, I have him here.
And, Your Honor, I'm going to be asking this to be put on recall. Your Honor, I can advise the court. We just received our filing packet this morning from the detective. It was an 80-page packet. We are actually in the process of typing the information right now to send to the e-file with the clerk's office.
When is this supposed to happen?
Well, Your Honor, my understanding is today's the 33rd day. We have till the end of the business today. I'm not asking for that long. It's just it should be a matter of minutes.
Okay. All right, Mr. Samuels, have a seat for one moment. I'm going to put your case on recall. Okay. I also have Lakia Fulton. Okay. Hello, Ms. Fulton.
Hi.
Ms. Fulton, you're here on a defense motion for ROR on the two charges you have. State.
Information has not yet been filed. She's entitled to an ROR, Judge.
Okay, Ms. Fulton, I'm going to grant the motion to release you on your own recognizance on these two charges.
Thank you.
You're welcome. Good luck. Okay, and then I have a second look on Ashley Perpinand. Hello.
Hello.
Please keep me posted.
Okay, so Miss Perpignan, you're here on a possession of cannabis charge, and state what was her bond set at?
One moment, Judge.
I'm sorry, she was set at what?
Her probation, I believe, has been resolved, Your Honor. She has a release date of May 29th. I'd be asking you to consider releasing Ms. Perpignan on her own recognizance, as the charge is, as of yet, unfiled. She can't resolve the matter. Ordinarily, she probably just would. But she is going to be released May 29th. I'd hate to see this charge be the thing that keeps her in jail.
Okay, and right now she has a $1,000 bond on this cannabis?
That's my understanding.
She was on probation for a drug offense when she was arrested on this. I don't think that just because she resolved her probation to a jail sentence necessarily should result in an ROR. I would have no objection with the court taking that into consideration and modifying the bond, which is in the court's discretion. Or if she wanted to resolve the state's offer, would be a withholding court cost if she wanted to resolve it.
Is this charge filed?
No, she was arrested May 10th. But it's up to her if she wants to either take an ROR or bond reduction or have the bond kept the same and come back to court. It's her call.
Ms. Perpignan, would you like to resolve this case today?
Yes, sir.
And the state's offer is what?
Withholding court costs.
Withholding court costs. Do you want to do it that way? Plead no contest and receive a withheld adjudication in court costs?
I'm not understanding what that is.
If you plead no contest, your sentence would be no conviction on your record, but you have to pay court costs, and the court would give you time to pay that money, and this would not be holding you in jail any longer. When May 29th rolls around in a few days, then you'd be released. This wouldn't be holding you. Or if you can make a $100 bond, you can bond out on $100 and come back to court again, if you'd rather do that.
No, I'll resolve it.
Okay.
All right, how do you plea, Miss Perpinand?
No contest.
All right, the court will accept your plea of no contest. The court's going to withhold adjudication and impose court costs. You are all set on this case, and as your attorney indicated, you'll be released on May 29th.
Thank you.
You're welcome. Good luck. Alex Coleman? Okay, thank you. Hello, Mr. Coleman.
How you doing, Judge?
Well, thank you. You're here on a possession of drug paraphernalia charge.
Yes, Your Honor. When Mr. Coleman, he's got a $100 bond on that. When he was arrested, he was also being held on a grand theft EOP. From what I can see, his probation was reinstated, so this is the only thing holding him. And since it wouldn't be resolving, it wouldn't violate his probation, the state would offer him a withholding court costs on the drug paraphernalia.
Okay. Mr. Vid, you want to explain to him his options?
Mr. Coleman, would you like to resolve this case today?
Yes, sir.
If you plead no contest, the offer from the state is a withheld adjudication, which means that you would not have a conviction on your record and court costs. Would you like to do that?
Yes, sir.
Okay.
All right. So how do you plead, Mr. Coleman?
No contest, ma'am.
The court is going to accept your plea of no contest. The court's going to withhold adjudication and impose court costs. And you're all set.
All right, so I'll leave today?
Is there anything else holding him?
No, not that I can see.
Oh,
Yeah, you're out today.
You're going to leave today. All right.
right.
Good luck. Okay. And the only other case I have is Mr. Samuels.
Just asking if we could put it on a brief recall. I was just told it was 5 minutes, Your Honor. They're just finishing typing up the information.
Okay. The court's going to be in recess for 5 minutes, and we'll pick up with Mr.
4727 CF10A at this time. He's got a $400 combined bond. The case that is being filed right now is his other case, 174790 CF10A, aggravated battery with a deadly weapon, aggravated assault without a firearm. Judge Calra just modified his bonds a week ago to $35,000 pretrial release GPS level 1. It's really up to Mr. Samuels whether he wants to take the ROR in this case or not, but my understanding is he will continue to be held on a $35,000 bond.
Okay, so explain to him his options.
Yes, Judge.
I'll find out right now.
Yes, yes, I see. All right. But you got to fill out the
Brian Greenwald.
stuff.
Brian Greenwald.
Hector? Just so you know, Brian Greenwald represents him on that other case.
Oh, so maybe we should call Mr. Greenwald. I didn't know that.
In fairness, Your Honor, the case that Mr. Greenwald is representing him on is not before the court, so I don't think we need to,
Yeah, no, I don't. It's that at this point in time, he just needs to decide whether you want me to leave the bond at $400 combined, so he gets credit for the time that he's serving, or if I ROR him, he's not going to get any more credit.
Right. And from what I believe from what I heard from my colleague, on the case that's filed, the more serious case, that's the one that he's represented by Mr. Greenwald. And I guess on 173727, he's represented by the public defender's office?
That's correct.
yes, sir.
Okay, then let me just talk.
So far.
Some more seconds.
Okay.
Judge, you want the ROR? Oh, well, sorry, Judge.
Could you pull the garbage can out? I got some stuff over there. Please. Thank you.
Judge, you want the ROR?
Okay, the court's going to ROR him in case 174727 CF10A.
Is it 47 or 3727?
4727.
47, thank you, Judge.
You're welcome. All right, good luck, Mr. Samuels.